Quickly, we have been following breaking news about the 1996 conviction of the Menendez brothers. LA County District Attorney George Gascon is reviewing new evidence of the case.
Let's get to that press conference being held right now by Mark Geragos, who represents the Menendez brothers.
Of the family on both sides. The reaction today by the DA is what I've been saying for the last basically year and a half. A year and a half ago, we filed a writ of habeas corpus. We presented two pieces of evidence. The one was a letter from Eric to Andy Cano, which predates the killings by 8 months. The other was a declaration by Roy Rosello, who is another victim of Jose. The combination of those two, we believe, provide more than ample basis to set aside the result of the second trial. For anybody who's been following this, you'll remember that the first trial ended with there were two juries. Out of those two juries, both of them voted more than half for not guilty on murder and were hung. By the time the second trial came along, it was on the heels, 8 days, frankly. Evidence started 8 days after the acquittal of O.J. Simpson. The rulings changed, even though it was the same judge. The prosecution changed, and frankly, they were deprived of what I consider to be a meritorious defense. They have now served 35 years. In that 35 years that they have served in prison, they've been model prisoners. They have worked tirelessly in the face of literally no ability or expectation that they would ever get out to reform not only themselves but the environment they find themselves. There has been a sea change in California. When they were convicted, California was in the throes of a prison expansion, a law and order expansion, and frankly, DA politics. And now we fast forward 35 years later, we've got a much more robust and evolved understanding of abuse, that yes, abuse can occur both with females and with males. I think it's time. Their family thinks it's time. I believe that what you saw today with District Attorney Gascon was that he has taken, I think, a rather bold step in that he has said he's going to make the final decision. It's it may not be a popular decision in prosecutorial circles, but I would think that in our culture, we've come a long way in the last 10 years, maybe 15 years. I think we're at a point now where any reasonable person taking a look at this case believes they should be out. And based upon that, I'm gratified. I'm hoping that sometime before Thanksgiving, which is when the next the response is due, that the DA will either concede the habeas or join in us in asking for a resentencing. And I'll take a couple of questions and then I'll turn it over to Brian Friedman. And he's not here, but Cliff Gardner, who is my co-counsel, deserves a lot of credit, because anybody who's followed this case knows he was the lawyer that argued this case in front of the Ninth Circuit. In fact, if you watch or listen to the Ninth Circuit argument, none other than one of the appellate justices back then said rather astutely that they certainly looked like they changed the rules of the game between trial number one and trial number two.